Now back to the MF Global story. If this were all a game of follow the money, a game that is, we'd be adding a new player to the board this weekend. The FBI, yes, that is correct. Now, the now bankrupt company, MF Global, is the subject of a formal investigation. The scope and focus of this probe is still unclear, and the FBI, not unremarkably, declined to comment. For more, though, let's bring in a man who has seen this kind of thing play out before. Doug Burns is a former federal prosecutor. He now has his own private practice, and he's here to talk to me and my colleague, Cristina, Alesci. Doug, does the mere involvement of the FBI on a formal basis make this a quote-unquote criminal investigation?
Yes, absolutely. And it's interesting that they would say, you know, we're in the case. You know, usually they might want to keep that a little closer to the vest. But basically, as you said right at the outset, I mean, they need to figure out, is money missing? What happened? I mean, notwithstanding that, if customer accounts, if money were taken out, that's already sort of a regulatory violation. And then the question is it more serious?
Does the FBI have more expertise in these matters? So who's involved, right? The CFTC is involved, the SEC is involved, the CME is involved. What is it that the FBI, in your experience, can find out that those guys can't? Is it because they have special subpoena powers, because as criminal investigators they know how to do certain things that the regulators don't?
No, I think that's right. I mean, you know, they have a lot of experience in these very intense document cases. You're talking about going through thousands and thousands of documents. They have forensic accountants and techniques, you know, to figure out potential sort of criminal issues. And I think they have sort of more manpower in that specific area.
So I have a quick question.
Sure.
When you look at what the line is between misconduct, which you referred to before, which is the commingling of the customer money with the firm's own money, and outright fraud, is there a very clear line there?
Yes, there is. In my experience, it's so interesting. I mean, basically, you know, you could go into customer A's account, move the money, and then for whatever reason, it's not in any way compromised. You follow me? So, you know,
it's not a big deal.
Could be a question. Yeah, it may not be such a big deal, as we were joking around earlier. But the thing is, once money that is taken and moved is then utilized, it can be for one of two purposes. I was in a case, a hedge fund case, where they used customer funds to run the business, and they got in serious trouble. But there's actually an even worse and more sort of criminal, sinister scenario, and that's where you take customer money and you use it for personal items like a house, a boat, a luxury car, art, you know, and so forth.
Yeah,
jewelry.
the fact that Jon Corzine has resigned, where does that take him out of the game? Is he still culpable?
Well, that was a very interesting maneuver, and he appears to have taken a page out of the Computer Associates playbook, where the CEO left that company very early on. Another very high executive got a very high sentence, 11 years. And so it's hard to say. But, I mean, one very interesting response to Stephanie's question is he left $12 million in severance on the table. And you can argue that two ways. You could say, well, wait a minute, is that consciousness that he did something wrong? It's too early.
Doug, are the interests of all the investigators aligned here, which is to say, once certain prosecutors get involved, does it become sort of a trophy hunting exercise for the guy who committed a crime, as opposed to satisfying the interests of the customers whose $593 million are still missing?
No, you made a very good point, which is sometimes you'll have the presence of criminal investigators, which I think you were saying, which can then come back and assist and help the regulatory process. And as far as the money, it's interesting. I mean, it's a very complicated bankruptcy case, obviously, and I was looking at it, and there's going to be a bulk transfer of all of the accounts to something like 5 other futures or commodities entities. But one lawyer who actually came on Bloomberg was saying that if you cashed out your position and were holding the cash, then you were frozen, as opposed to those whose account. Yeah,
it's kind of like the Madoff situation.
It's very similar. And then, of course, another trustee for another entity, similar futures entity, said that the money's going to be tied up for a long time, which is not surprising, obviously.
Now, I know a lot of the customers have been angry at the exchanges as well.
Yes.
Because of their role in this.
Sure.
I mean, is there going to be any investigation or maybe increased oversight of those entities?
People were raising that, and they were saying, well, wait a minute, you know, does the CME have liability morally or legally and so forth? It would sort of be like suing the New York Stock Exchange for the malfeasance of an entity that you're dealing with. So it's probably difficult. But your point is very good, which is there's been a lot of outcry already that there's got to be more regulation and tighter control. And there was some very specific, very complicated transactions, the terminology of which escapes me at the moment, which they said they want to eradicate and get rid of, having to do with exchanging customer accounts for borrowing.
Well, one of the questions that we've been wrestling with all weekend long, and I know you can't answer it directly,
Sure.
but I'm interested to know your thoughts. The money is missing,
right?
But somebody, right, at least two people know where the money went. If somebody made a decision to spend that money on something, whether
right.
it's a matter of posting more collateral,
yes,
that person at MF Global knows.
Right.
And the person on the other side, presumably at a bank or another dealer,
right.
knows because he or she received the funds. Why don't we know that yet?
But that becomes a really interesting calculus, because the point is, once you're in a really high-level white-collar landscape and people get attorneys and so forth, they may decide to invoke the Fifth Amendment privilege, and then you sort of go back and forth. You know, it was funny. I was watching a television show last night, of all things, and they say, he won't testify unless he gets transactional immunity. I said to my wife, you don't get transactional immunity in federal court, meaning for the whole event. You get a limited form of immunity, and it kind of goes back and forth, and they'll try to develop information. But they may be stymied. It's hard to say.
And Doug, where does the buck stop? You have MF Global, you have Price Waterhouse, who is responsible for auditing them.
Right.
The rating agencies may have known something somewhat early on. Then you have Jeffries, who underwrites a debt deal in August.
Yes.
Who's culpable here?
Well, that draws a distinction, in my opinion, between criminal and civil liability. In other words, in a criminal case, back to Erik's point, if they can specifically establish that people knew and compromised customer accounts, then you're into a criminal case. But to your question, Stephanie, I mean, basically, you know, the lawyer who came on Bloomberg in terms of litigation in the bankruptcy, what they call adversary proceedings, was saying that he was going to name a lot of people. So the answer to your question is, in a civil case, they could theoretically name the CME and others and say that you were negligent in your oversight.
If you had to guess, how many lawsuits would you think we're going to see here?
20, minimum.
Minimum of 20?
Yeah, that's just off the top of my head, though.
Wow. And how long, Doug, before we actually, again, I know it's a question you can't answer directly because you're not involved, but why is it that we don't know where the money went? What is it about? I mean, in your experience, is it something like shoddy accounting, or more to the point that you were making before, that some people who could be talking aren't talking because their lawyers have said, keep quiet?
It's a little bit of both. And also, you're talking about something like $41 billion. You know, you have to look at the landscape. It'd be one thing if this was, 90% of the funds, but it's a smaller portion. I mean, it's still very serious. But the point is, it's so complicated, and there's so many accounts that you need basically what we would call sort of a forensic accounting of what happened. And before that's done, we're sitting here speculating. I mean, I had read, one source said 633 was missing. Now it's down to 593. But again, it's a lot of money.
It certainly is a lot of money. At that point, I wouldn't say $100 million is a rounding error, but we're still talking about hundreds of millions. Doug, always good to see you.
Thank you.
Looking forward to our next conversation. Doug Burns, former federal prosecutor, now with his own practice, knows a lot about cases like this. And when there aren't answers, it certainly pays to get insights like that.